In today's case, we're heading to Michigan. The defendant in this matter was arrested for operating a boat while under the influence. He identifies with sovereign citizen ideology and has previously had courtroom exchanges that did not go in his favor, including a contempt finding that resulted in a short stay in custody. This hearing focuses on probable cause. The defendant has submitted multiple motions seeking suppression of evidence and dismissal of the charge. The court will address each in turn.
All right, and Mr. McLeod, good morning, sir.
Morning.
We're here for a docket call as well as several motions that you filed up, that you noticed up. One of them does require some testimony. That was the motion to suppress the chemical test results. Your filing the motion triggers the prosecutor's burden to establish that that search was taken properly. Is there any opening statement you want to make, Mr. McLeod, about your motion to suppress the chemical test results? And you'll have an opportunity to argue after the testimony as well. Any opening statement you want to make?
Well, I just received an email from Julie Rattel. I don't know if she's a court administrator or clerk.
She works in the prosecutor's office.
Okay, I just received an email from her on Friday with the warrant that was never found in Discovery or anywhere. It just turned up Friday magically, I guess. Okay. So I'd like to open with that.
Before testimony begins, the defendant objects to the timing of receiving his arrest documentation. He suggests that the delay affects his ability to prepare. The court notes the concern and indicates it will be addressed in context, but the hearing proceeds. It's also worth noting that appointed counsel was available to him. He declined representation and chose to argue the motions on his own behalf.
Initially on that day, we were doing a BUI patrol. Other COs notified that there was a boat with expired registration. Subsequently, we found out that the defendant was intoxicated while he was operating the vessel, and that led to the arrest of him. Once he had exited the vessel, I noticed that he had to use the post on the dock for his balance to get out of it. He stumbled and swayed back and forth along the dock and up the ramp of the boat ramp. While talking to him, I observed slurred speech. I noticed that it took him about 10 seconds just to put on one of his sandals. Myself and Officer Listenfeltz, we advised him that he was going to be under arrest for BUI and asked him to exit the vessel that he was in. He refused. Officer Listenfeltz got inside of the vessel with him. The defendant pulled away from Officer Listenfeltz. A scuffle erupted. He put his arms in front of him so that way he couldn't be cuffed. Time I pulled out my taser, I took the cartridge off so that I could use the dry stun option. And then finally, Officer Listenfeltz was able to pull his right arm behind his back and handcuff him.
The arresting officer testifies regarding the initial contact on the water, the observations made during the encounter, and the indicators that led to the arrest decision. The testimony establishes the sequence of events and the basis for probable cause. Cross-examination does not materially change the factual record. The officer's account remains consistent.
Argument on the motion to suppress the chemical test results, Mr. McLeod?
Well, I've already shown that the warrant's invalid. It's got unsigned documents that are supposed to be accompanying it. So I would say that it should be upheld that this warrant was invalid. It was executed improperly. It was not served on me. It was not given to me by release. It was not found in Discovery with 3 requests. So it's very convenient that it turned up Friday.
All right, thank you, Mr. Juliet.
Just briefly, just based on, I understand the court has to make a credibility assessment here on whether the officer did in fact type up a search warrant and serve it on the defendant. He certainly had probable cause to draw blood. That's common procedure when somebody refuses a chemical test. The defendant displayed signs of intoxication, which led to the arrest for voting under the influence. He refused a chemical test when offered one. Based on the observations of the officer, he had probable cause to submit for a search warrant for blood. He did that. He typed out the affidavit, and it looks like, to me, it looks like it's electronically signed. On defendant's exhibit 3, he said that he served it on the defendant, left it in jail. So I would ask the court to deny the defendant's motion.
All right, well, the motion was to suppress the results of the blood test for alcohol in Mr. McLeod's body because the blood was drawn without a warrant. based upon the officer's testimony in People's Exhibit 1, that blood was in fact taken pursuant to a search warrant issued by a magistrate. So therefore, it didn't violate the Fourth Amendment. The complaint and affidavit and warrant that the defendant's referring to are the charging documents for the issuance of the charge. It doesn't have anything to do with the drawing of the blood. There was a warrant for the drawing of the blood, and it was drawn. And the officers testified that they did leave the warrant and tabulation and affidavit at the jail for him. Whether that got to him or not is frankly immaterial. Even if it didn't, that doesn't invalidate the action of drawing the blood. That would violate the Fourth Amendment if it was done without a warrant, but it was done with a warrant. So that motion is denied. Mr. McLeod, you also have a motion to dismiss on procedural grounds for a probable cause conference not being timely held or validly waived. Any additional argument you want to make on that motion?
Yeah, the waiver was supposed to be signed by both parties. That's state law, and only the prosecuting attorney signed it. And then neither my defense attorneys or myself signed it. I'm just curious how that transpired.
Hey, Mr. Juliet.
Just briefly, I did submit a response to this, and I did research the case law on this. I did confer with district court. It doesn't look like a probable cause conference was held, but I did read the case cited by the defendant in his motion that dealt with the failure to hold a preliminary examination within the statutory time period. That doesn't warrant dismissing the case. If anything, that would call for a remand, perhaps to district court.
Remand back to district court.
But in this case, and in the case that I cited, there has to be some showing of prejudice by not holding the preliminary exam or probable cause conference by analogy. In this case, there was a preliminary exam that was held and it was bound over by Judge Bisnot. So I don't think there could be any prejudice by failing to hold a probable cause conference.
All right, yeah, Mr. McLeod, the purpose of the probable cause conference is to see whether somebody wants to run the prelim or waive the prelim to address any bond issues. You were already free. You weren't being held in jail, and you did run the prelim. So there's, even if a probable cause conference wasn't held, there's no
prejudice. Could have stopped a lot of those procedures because the probable cause is all hearsay.
When the court turns to the defendant's suppression arguments, the judge responds directly. The officer has testified under oath regarding the reason for the stop and the arrest. That testimony forms part of the probable cause analysis. As for the defendant's reference to procedural conferences, the court clarifies that not every requested conference is guaranteed by rule or statute.
No. But see, probable cause conference, the prosecutor doesn't have to prove probable cause at that hearing. They have to prove it at the prelim. The probable cause conference, it's maybe not a great name for it, but that conference is just to address, are we running a prelim? What issues might there be at the prelim? Should the defendant be released from the jail pending the prelim?
But does it not still need to be waived by both parties?
It does, but the fact that it didn't has no prejudice to it. So defendant moves to dismiss the case on the ground the probable cause conference was not timely held and that it was not validly waived.
Actually,
I'm making my ruling now, Mr. McLeod. Defendant relies on People v. Weston involving the failure to timely hold a preliminary examination for an in-custody defendant. His reliance is misplaced, however. In People v. Crawford, the Michigan Supreme Court held that the Weston remedy must be invoked prior to the preliminary examination being held. In any event, Weston did not address probable cause conference, which did not exist at the time. The probable cause conference is to address possible plea negotiations, bond matters, and the scheduling of the preliminary examination. Defendant has shown no prejudice, even if a probable cause conference was never held and not validly waived. Moreover, defendant exercised his right to the preliminary examination. Dismissal is an extreme remedy, and defendant has not shown that it is warranted. Accordingly, his motion to dismiss is denied.
You say exercise my right to preliminary. Wasn't that kind of a forced situation?
It's your right to have a prelim, and you exercised it. So you exercised a right, and it was held. So there's no harm to you. You exercised a right. All right, now you filed a second motion to suppress based on lack of sufficient basis for law enforcement officer to make contact. I'm not entertaining oral argument on that motion. It's just a repeat motion. Defendant moves to suppress evidence and dismiss the case based on a lack of sufficient basis for the law enforcement officer to make contact with him. and a lack of evidence of his intoxication or impairment. This motion essentially raises issues that were argued in defendant's first motion to suppress. As explained previously, the officer had legitimate grounds to approach defendant based upon his observation of defendant operating a marine vessel with expired registration. Upon initial contact, the officer detected signs of impairment. Therefore, both his initial contact and his investigation were entirely lawful. Accordingly, defendant's second motion to suppress is denied. Mr. McLeod, you also filed a motion to reconsider the reconsideration. That's not really authorized in the court rules. I'm not entertaining oral argument on that. Defendant moves for reconsideration of this court's recent order denying his motion to reconsider this court's denial of his motion to suppress evidence for an allegedly illegal police contact.
One of the filings effectively asks the court to reconsider earlier denials and then reconsider those reconsiderations. The judge explains that motions for reconsideration require a legal basis, such as new evidence or a clear error of law. Absent that, the court is not obligated to revisit the same issue repeatedly.
As the moving party, defendant bears the burden of demonstrating a palpable error by which the court and the parties have been misled, and that a different disposition must result from correction of the error. Moreover, a motion for reconsideration which merely presents the same issues ruled on by the court, either expressly or by reasonable implication, will not be granted. Defendant essentially raises the same issues that have already been briefed and argued. Defendant has failed to meet its burden of demonstrating a palpable error. Accordingly, the motion for reconsideration is denied.
I think you're failing to notice or recognize the lack of jurisdiction that you have.
Well, that brings us to you filed three more things, and I want to address those today because today was the motion cutoff. So you've got a motion.
And I don't consent to that anymore either. I need more time to file these motions.
Nope. Today's the motion cutoff. You filed three more. I'm going to hear them today. You have a motion to dismiss for lack of jurisdiction. We've addressed the jurisdiction previously.
You don't have jurisdiction.
I already ruled that I did. This motion,
have your own jurisdiction.
this motion is denied. This court does indeed have subject matter jurisdiction over the charges by law.
Personal or subject
and personal
jurisdiction. I object.
Your objection is noted and your motion is denied. All right, you filed a motion for disclosure of bonds. I don't even understand what you're talking about. In that
I don't
motion.
know. Somebody else handled that.
What's that?
I don't understand.
You don't understand it either? Okay.
A recurring theme in the defendant's arguments is the assertion that the court lacks authority or that procedural defects invalidate the case entirely. However, assertions alone do not establish legal error. Motions must be supported by statute, case law, or procedural rule. The court evaluates the claims against established law and finds no basis to grant relief.
And that motion is denied. It's legally nonsense.
So all this proceed.
And Mr. McLeod, you're filing, I mean, I'm letting you represent yourself and you're filing motions that you're telling me today you don't even understand. That's not a very responsible way to proceed. There's also a motion to recognize your subrogation rights. I have no idea what you're talking about. Do you? Can you explain it to me?
It's not necessary.
That motion is denied. It again is legal nonsense.
By this point, the volume of filings does not change the legal standard being applied. The judge addresses each motion, but quantity does not substitute for legal merit. The court's role is to determine whether probable cause exists, not to entertain unsupported jurisdictional theories.
Motion to stay the court while I leave to bring this into the Western District Federal Court where it's supposed to be held. There's questions that you're answering and having opinions on that you don't have the jurisdiction to have answers. I brought that up in several motions and you keep claiming that you do. It's clearly written in the consent decree that you don't.
It's manifestly untrue, Mr. McLeod. I mean, the consent decree doesn't mean that you can drive around on a boat drunk. And if the police catch you doing that, that comes in state court. It doesn't come in federal court.
Aren't you supposed to be an unbiased participant?
I am unbiased. You may not have been drunk. That will be for the jury to decide. I'm just saying I have jurisdiction over that allegation. It's not a federal.
You're interpreting the fact that you're trying to say that I was supposed to notify him that I'm Native American, and that's not true. And that's your interpretation. You have an opinion.
All right, that's fine. And if I'm wrong, another court can tell me that
So
I'm
I
wrong.
motion to stay the court so I can take this to the proper court for an opinion on what you're trying to have an opinion on that you're not on that.
Denied.
Ultimately, the judge denies the motions and finds that probable cause has been established. The case will proceed through the normal criminal process. This hearing serves as a reminder that courtroom arguments must align with recognized legal principles. Personal interpretations of authority or jurisdiction do not override statutory law. Subscribe to my channel.